I'm Ashley Church from the Israel Institute of New Zealand, and I'm here this morning with Dr. David Cumin, also from the Israel Institute, to talk about a report from an international think tank called THINC. David, what is THINC?
THINC is the Hague Initiative for International Cooperation, so it's THINC with a C. And their stated goal is to, quote, enhance the awareness of the dynamics of international law and its impact on decision making to advance peace and security. Essentially, they are a network of practitioners and scholars of international law. They're experts who issue opinions and make legal cases for how international law is applied, particularly in the UN, because of course the unfair application of international law undermines any efforts for peace.
Okay, so how did they come to their conclusions? What were the guiding principles?
Well, the report states three guiding principles that they used. The first was, as I said before, that international law needs to be applied fairly across all countries and states, and that legal rules need to be applied to conflicts fairly. The second was that there's a clear distinction between international law and policy, and the United Nations resolutions don't necessarily reflect a true statement of law. And the third guiding principle was that the United Nations institutions don't have authority to resolve disputes between states or international actors unless they both agree. There were 24 experts in international law that attended the conference, and they convened to investigate the interpretation of international law as it was applied to the International Court of Justice opinion in 2004 and the UN Security Council Resolution 2334 in particular.
And so what was the outcome?
Well, these 24 experts came to the conclusion that there needs to be a review of the International Court of Justice opinion and Resolution 2334. They found that, quote, the processes leading to the 2004 opinion and Resolution 2334 fell short of open, balanced and thorough consideration of all the relevant factual and legal issues. The report also stated that the 2004 opinion and Resolution 2334 did not adequately take into account the legal, historical, political and military complexities of those territories and peoples in Israel and the Palestinian authorities. For example, Judge Higgins, in her separate opinion that was written for the International Court of Justice, also said that the law, history and politics of the Israel-Palestine dispute is immensely complex. Context is usually important in legal determinations, and she found that the history, as recounted by the court, was neither balanced nor satisfactory. Essentially, we have a solid group of international law experts that are condemning Resolution 2334.
And so what are the implications of their report?
Well, their report makes clear that United Nations Security Council Resolution 2334 was a politicisation of the United Nations processes in order to attack the Jewish state. International law experts have now given their considered opinion that clearly shows a biased and improper use of the United Nations in that resolution. It confirms, unfortunately, and it compounds the disappointment that many Kiwis felt after Murray McCully's actions last year. And the real implications are that New Zealand is no longer an honest broker of peace and has abandoned international law principles to join the likes of Malaysia, Senegal and Venezuela, who also co-sponsored the resolution, in order to attack Israel.